In America, the government doesn't get to pick winners and losers in the marketplace. Yet states and cities throughout the country block new business to protect established interests. That's when IJ steps in. Awa Diagne has been braiding hair for 30 years, but when she tried to open a braiding salon in an Atlanta suburb, the town told her it would provide too much competition. So Awa and IJ are fighting back. I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, joined by co-host Keith Neely. We're talking with IJ attorneys Renee Flaherty and Will Aronin about how IJ is protecting the right to earn a living. This is Beyond the Brief. So Will, tell us about Awa and what's going on in South Fulton.
Awa is amazing. She's just like the perfect example of the American dream. She came here 33 years ago or so from Senegal. She got her U.S. citizenship, and she loves African hair braiding. It's what she's done. It's how she's supported her family in Georgia for decades. In 2021, she and her family actually moved from Atlanta to the city of South Fulton just to put her two twin daughters into like this really great school. The plan was to continue to braid in Atlanta, but unfortunately, like literally the day after they moved into the new house, her husband was hospitalized with COVID and he never came home. So Awa could no longer do that commute, and she decided that she wanted to actually open up a storefront, like right by her home, right by her daughter's school, in South Fulton, and start braiding hair there.
So what happened when she tried to open the shop?
So that's the end of the story. This is the United States. Like, you get to open a business when you want to, and the market takes
We're
over,
done here.
right?
Fastest episode ever.
That's how this is supposed to happen, right? No, that's not, of course, not what actually happened. So she goes through, she speaks to the city, she finds this perfect lease. She spends thousands of dollars on security deposits, on doing a build out for the braiding shop. She works with the zoning commission, no issues, huge community support, wonderful. We're all good here. This is America. Then the city council gets involved because they need to approve the final permit. And a local salon owner complains and saying, I don't want the competition. I don't want another braiding shop near me. I apparently get to keep all of these customers for myself. So that other salon owner complains to the city council, and the city council holds a hearing. They hold a second hearing where a council person literally says,
we want to put you in a place where you are most successful and you're not competing against, that no one is competing against you and you're not competing against anyone.
In case you want this more out of central casting, they even said that Awa should work with the city's, quote, planner to decide where her business should be. And then, despite the tens of thousands of dollars she spent, denied the permit, and Awa is not allowed to open her braiding shop, the thing that she's been doing literally for decades.
Renee, I know you've litigated a lot of economic liberty cases. Oftentimes we find out these sorts of protectionist statements and smoking gun emails that we have to spend months getting during discovery. How often is it that you find such openly protectionist statements being made on public record at a publicly available council hearing like this?
Honestly, not very often. I think there's kind of protectionism on a large scale, like occupational licensing, certificate of need laws that IJ challenges a lot. And there's protectionism on a smaller scale, like what's happening to Awa. Zoning officials just being absolute tyrants. And I think in this instance, they just couldn't help themselves. And they just said exactly what they were doing. And whenever we discovered that, we thought, well, I think we have a pretty strong case.
No kidding. I mean, this is as open as I've seen it.
I mean, they straight up said the quiet part out loud. It was kind of amazing.
Goodness.
So how big of a problem is this issue of economic protectionism? I mean, it happens a lot in IJ cases, but is it, how widespread is this?
Unfortunately, it's very widespread. In fact, in a very famous case out of the 10th Circuit, a judge said that it's like baseball. Protectionism is one of the favorite pastimes of American lawmakers, handing out favors to smaller interest groups. And since IJ's founding, we've been fighting cases against protectionism, including a lot of cases involving braiding and cases involving zoning like Awa's.
So the town's behavior here is kind of especially bonkers because IJ, and you in particular, Renee, just litigated and won a case at the Georgia Supreme Court saying basically that, among other things, economic protectionism isn't, permissible under the state constitution. So how is this even happening? And can you tell us about that previous case?
That's right. So it's not a coincidence that we brought this case when we did, because just last year, IJ won a case involving lactation consultants, which are, of course, just people who teach women how to breastfeed. And this is something that women have obviously been doing for each other for thousands of years, and it's safe, and there's no need for the government to get involved. But Georgia, a few years ago, decided to license lactation consultants. And this license wasn't a trivial thing to get. Our client, Mary Jackson, had over 30 years of experience as a lactation consultant. She taught doctors and nurses about breastfeeding, and she didn't qualify for the license, which is kind of amazing. And it's only because she didn't have the right kind of private certification. There are essentially two kinds of private certifications for lactation consultants, and one of those groups lobbied for this licensing law, and that's why it's protectionist. They're, obviously trying to keep other people out of the field.
You have to pay for our certification in order to do this.
Right, and it's the most rigorous certification to get. You have to go to college, you have to pay hundreds of dollars to take an exam, and they were successful in Georgia getting this passed. They failed in a lot of other places in the country, but we brought a lawsuit challenging it in 2018 and actually got up to the Georgia Supreme Court twice. The first one was on a motion to dismiss, where the trial court dismissed us because they said that Georgia didn't even have a right to economic liberty. Like, you didn't have a right to earn an honest living in Georgia, which of course is absolutely crazy. And so we very easily got that reversed. And the court said, not only do you have this right in Georgia, but it's actually really important under the state constitution. And so we went back down to the trial court and we built a record through discovery showing that there's no need to license lactation consulting because it's safe. And the only reason why this licensing law got passed was to protect certain kinds of lactation consultants from competition from others. And we won that. And in the process, the Georgia Supreme Court said that protectionism is not a legitimate interest or reason for interfering with the right to earn a living.
But speaking of the win in Georgia, I know this is part of several state court victories that IJ has had in the economic liberty space. Could you talk a little bit about why we're trying to win these cases in state court and get this elevated standard of review as compared to what you sometimes see federal courts do? Rational basis when I was in law school was taught to me as just a rubber stamp. If rational basis applies, the government's going to win. So tell us a little bit about how the Georgia case fits into that broader work at state high courts to try to really reinvigorate economic liberty protections.
Sure. So these cases are really hard to win in any court, and it's because of what you said, the rational basis test, where the government gets to interfere with certain of your rights, particularly those that aren't specifically enumerated in the Constitution, for basically any reason it wants. And, not to throw the federal Constitution under the bus, but state constitutions often have greater protections for unenumerated rights than the federal Constitution. And so, though we've had a lot of success in federal court bringing these kinds of cases, and we continue to have success, we've been bringing them in state constitutions. For example, the first big one we brought was in Texas involving eyebrow threaders. So like Awa, it was something related to the cosmetology field, because the way people who provide these kinds of services are regulated, there's a very obvious mismatch between what they're doing and the way they're being regulated. And so that's one of the reasons we bring those kinds of cases. And in Texas, we won, and the Texas Supreme Court specifically said that the Texas Constitution provides more protection than the federal Constitution. And then we won a similar case in Pennsylvania involving real estate licensing and whether you needed to be a full-on real estate broker just to manage Airbnb properties. And we won that, and the Pennsylvania Supreme Court said that it provides greater protection than the federal Constitution. And then we had the Georgia case, and we've continued to bring other cases in state court.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. For a limited time, when you sign up to donate $22 a month by October 15th, you'll receive our exclusive IJ 2025 calendar. This special calendar features inspiring stories and images of the courageous people we represent. Monthly donations are convenient and cost-efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/calendar.
And I think in North Carolina, this wasn't an IJ case, but they recently had an opinion applying their law of the land clause, where they also talk about economic liberty as a protected interest under the state constitution. Is that right?
That's right. And that case involved COVID-19 closures, and we did an amicus brief in it. But basically, they said that North Carolina actually has a special provision that protects people's ability to earn the fruits of their own labor.
Right.
So it's a very unique constitutional provision. But the same test applies to due process claims as well. And the North Carolina Supreme Court said that that provision provides more protection than the federal Constitution. And I've actually got a case pending at the North Carolina Supreme Court about the state's certificate of need law. And so that was very excellent. Because
always good news to get, right?
Exactly. We have a due process claim in that case. And so we're going to see what bearing that case has on our case.
So back to Awa, we're representing her in this lawsuit against South Fulton. So can you tell us a bit about sort of how we found her and kind of how the lawsuit builds on the previous Georgia lactation case?
Yeah, so what happened to Awa got a little bit of local coverage, and I think 6 or so people independently reached out to IJ to be like, hey, have you seen this case? This is outrageous. You should look into it. And we just kept getting those emails and calls. So yeah, we went down and we looked into it, and it was absolutely outrageous because for wins like Renee was talking about, things like Patel, things like Ladd, things like the lactation consultant case in Georgia, like this is one of the major things that IJ does. So people realize that they should reach out to us for it. So we met Awa. We realized she's even better than we thought, and like better than we even hoped for, and we brought the suit. And it builds on it just exactly like Renee was saying. It builds on the win because we are going to cement that protectionism is not okay. It doesn't matter if it's in the zoning context. It doesn't matter if it's in the licensing context. The government can't use it's unbelievable police power. It can't use its power to stop people from doing something simply to protect some other business. They can't do that, period. End of discussion. And we are going to solidify that in Georgia and everywhere.
You brought up zoning, and Awa's case is technically also part of our zoning justice project that we recently launched. So can you kind of talk about the sort of how this involves zoning? Yeah, so the reason that under South Fulton's code that Awa even had to get this permit, this quote special use permit, it was a zoning decision. The city council, in its, let's just call it infinite wisdom, decided that the zoning rules mean that you need to get this special permit because you're a beauty salon, and we think that requires a permit. And really the whole thing is just designed, again, it is all protectionism. It's turtles all the way down. You just keep going. Everything about this is designed to keep the favored businesses from having to compete, to actually having to lower their prices or anything else. So they use the zoning code. Sometimes they use licensing codes, whatever it may be. And we're committed to ending that type of practice. Like in zoning, we're committed to ending other types of zoning abuses, preventing people from using their land. And this is just step 1 or 2 of very, very, very many.
Renee, Awa's is one of a long line of IJ cases involving braiders. This is something that we've been litigating now for close to 30 years. Maybe as long as IJ has been around, we've been representing braiders. How is this case different from some of those past cases, and how did IJ get so heavily involved in the braiding space in the first place?
You're absolutely right that IJ's very first case was about braiding, but Awa's case isn't just about braiding. It's not about whether she needs a license to braid, for example, which is what our other cases involved. This is about her using her property or property that she leases to earn a living braiding. And our first case was in Washington, D.C., and we represented a braider and his wife who just wanted to braid. And this is a job that a lot of immigrants do. It's a job that they learn in their home countries, and they don't need any specialized training to do. But it's regulated as cosmetology in a lot of places. And there's a huge mismatch there. And DC wanted him to be either a cosmetologist or a barber. And obviously he wasn't interested in doing that. And so he signed up with IJ, and we challenged it. And in that particular case, the city ended up giving up. And so that was great. And I remember when I was litigating an economic liberty case in DC, I was always telling people about that because I was really hoping that DC would give up in my case, and they didn't. But they did in that case. And it was kind of the first in a series of victories involving braiders. And we've actually been successful in federal court with braiders, which is really extraordinary. And so we have brought those cases challenging braiding licenses. We've also had tremendous success legislatively, getting the laws changed so that braiders are exempt from cosmetology laws or have their own specialty licenses. And so that has continued to this very day. And now we're doing cases with braiders that aren't even about licensing.
How does that affect sort of people that aren't braiders, right? Like when we win these cases, is it sort of limited to that industry, or, what's sort of the follow-on effect of that?
It's not limited to that industry. Like in Georgia, when I won on behalf of the lactation consultants, it was about everyone's right to earn a living. And that's the same thing here with Awa. It's about her ability to use her property to earn a living. And it wouldn't really matter what she was trying to do in that shop. Although the city of South Fulton has probably one of the most extensive zoning codes I've ever seen. And they delineate and spell out basically every occupation you could ever think of. So to them, it matters a lot what Awa is doing. But to the Georgia Supreme Court, it doesn't. She has the ability to engage in a safe occupation that's not harming anyone else without unreasonable interference from the government.
If Awa were doing something else and instead of braiding, would she be sort of captured by some other aspect of the zoning code, or is it sort of uniquely oppressive in this space in particular?
Well, if she wanted to set up a school to teach people how to braid, then she wouldn't need a special use permit. And that's actually one of our claims. We have an equal protection claim in addition to our due process claim, because the way that South Fulton has kind of divided up their zoning code and said this is who needs a special use permit and this is who doesn't, that's another separate problem with what they're doing besides the protectionism.
That's so bizarre. So she could teach other people to braid, but she can't braid herself, even though presumably like the act of braiding is kind of involved while you're teaching braiding. That just sounds completely insane to me.
Yeah, that's right. And I have no idea what they could be thinking, honestly. Although we've learned a little bit about the history of their entire zoning code. South Fulton is a pretty new city. I think it was incorporated in 2017. And so their zoning code is very new. And they tried to pass an ordinance in 2020 that said that you can't have the same kind of business within a mile of another kind of the same business.
That also sounds unconstitutional.
Oh, right. Super unconstitutional.
Deeply unconstitutional.
And they failed. They didn't pass the ordinance. But then they said, well, let's create this special use process that will allow us the discretion to basically do the same thing.
But it's like crazy. It really only applies to small businesses, to people who are trying to get started. Like you drive through that town. It's a beautiful town. Like there's a Starbucks right next to or across from a Dunkin' Donuts. There's, as you would expect, like 2 fast food places right next to each other. Big, huge corporate interests. They can fight this issue. But like these are the types of policies that end up applying to people like Awa, to people like all of IJ's clients, just people who are trying to start up a new business and provide for their family. They're the ones who fall traps to it.
And if I recall, we launched this case pretty quickly after we found out about Awa's situation. I happened to be working with Renee on a braiding case at the time, and I remember we were talking about how busy we both were, you guys preparing for this launch. How long from the date that we found out about Awa's situation to the date of the launch was there? Like weeks?
We launched this case from the time we met her until filing in 12 days.
That's incredible.
It was a lot, but it was a lot of fun too.
That's, I mean, even by IJ standards, and we move very quickly in a lot of our cases. 12 days is a heroic lift to work up a case, to, make sure that the client is someone that we want to represent. I mean, was it just a nonstop sprint for those 12 days?
Yes, it was. And the reason for it is because there's a 30-day statute of limitations if you want to appeal a zoning decision like this, which to me is just an entirely separate problem. Because imagine if Awa hadn't found us. What kind of ordinary person first would be aware of the 30-day statute of limitations and then would be able to file something that the procedure for filing had a lot of sort of procedural traps for the unwary. So, if you don't have a lawyer who knows about these kind of things, what are you going to do?
And no other lawyer would take this kind of case, likely.
That's right.
Or at least they'll be extremely expensive. Like someone starting up a business,
Right.
You'd have to pay a huge amount of money to pay a lawyer to do the amount of work we did. It's honestly a privilege to be able to do that for someone like Awa.
How did Awa feel when you guys told her that we were going to represent her?
She was relieved. She was definitely stressed. This entire process has really had an effect on her and her family because I think she knew it wouldn't be easy. She knew there would be a lot of paperwork, but her reaction has basically been, this is not the America that I've sort of grown to know and love since I moved here. What is going on? I really don't understand. And unfortunately, we had to come in and explain to her that this actually isn't that uncommon.
But I will say, it's hard to describe how wonderful Awa is. She's just really sweet and awesome. When we decided to do the case and we all agreed to move forward, there was a lot of hugging involved, mostly from Renee.
So what happens next for Awa in the case? Sort of what's the path from here?
We filed at the end of August, and the city of South Fulton had 30 days to respond. And so that is next week. And so we'll see. We haven't heard a peep from them, and they haven't made any comment in the media. And so we don't really know how they're going to react. And we'll just have to see what happens when they respond next week.
All right. Well, good luck, and thanks so much for coming in and talking with us.
Thanks for watching today's episode. Our last episode was about civil forfeiture and how carrying cash is not a crime. Some of you had some great questions and comments, so let's take a look at a few. Steve Ladner writes, people that pull you over to ask if you're carrying a large amount of cash are not concerned about your safety and security. I couldn't have put it better myself, Steve. Pilot Plater writes, Steve Lato made me aware of this issue years ago. Thank you for your work, IJ. Well, thanks for your support, Pilot. Steve Lato has done a lot of great work in this space, and we're grateful for him and for people like you who care about this important issue. George Washington Laser Musket writes, remember kids, if the police ask you if you have cash, you respond with, why? Are you asking for a bribe or something? Well, that's a fitting response for Mr. Washington, but be careful though. Officers aren't always good at picking up on jokes. Just ask former IJ client Waylon Bailey, who jokingly compared the COVID pandemic to a zombie apocalypse on his Facebook page in March 2020. Waylon's tongue-in-cheek joke, which even referenced World War Z star Brad Pitt, led Louisiana sheriffs to storm his home and arrest him under the state's anti-terrorism law. Fortunately, Waylon found IJ, and we helped him successfully sue those officers for violating his First Amendment rights, winning a landmark decision at the United States Court of Appeals for the Fifth Circuit just last summer. All this to say, joke carefully, Mr. Washington, joke carefully. Ross writes in, the law should require that police or government agents cannot seize assets or effects unless an arrest is made. Simple as that. We absolutely agree, Ross. That's why we at IJ have created model legislation that states can use to replace civil forfeiture with criminal forfeiture, which requires a criminal conviction before the state can try to forfeit a person's property in court. A number of states, including Nebraska, New Mexico, and North Carolina, have adopted similar laws to our model bill. If you'd like to see your state join that list, check out the civil forfeiture page on our website at www.ij.org. Backwoods Restoration writes, this garbage scares the snot out of me. I have to travel from 400 to 2,000 miles to buy cars. Yes, I could have bank checks, traveler's checks, etc., but my banks mostly are not where I'm traveling, so they can't break a check. Plus, you can't haggle price without cash. Just one of these stops would pretty much destroy my tiny business. You make a really great point, Backwoods Restorations. Millions of Americans from all walks of life prefer to do honest business using cash. For some, it's easier. For others, it's more flexible and profitable. But most important of all, it's perfectly legal. Carrying cash in and of itself is not a crime. But civil forfeiture treats carrying cash like a criminal offense, endangering American civil liberties and livelihoods in the process. That's why we at IJ are working so hard to put a stop to it. Riaj writes, problem with all this is it'll cost more time and money to get said money back than if you just let it go. The government knows this and uses that to abuse this power. That's a great point, Riaj. In fact, we have numbers backing that up. The third edition of IJ's groundbreaking study, Policing for Profit, found that the typical cash forfeiture involved just a few hundred or a few $1,000s, far less than what it would take for that person to hire an attorney and contest the forfeiture through the legal process. As a result, civil forfeiture often ends up harming those on a limited income the most because they just don't have the resources to fight back. Fortunately, thanks to our generous donors, we're able to help innocent Americans fight back against the forfeiture machine and retain their property. If you or someone you know is facing the civil forfeiture of their property, let us know by clicking on the Report Abuse button on IJ's website. Robert Tyree writes in, hello IJ, how would one push for a law requiring a double-blind test for these drug-sniffing dogs? That's an interesting question, Robert. States could adopt laws requiring drug-sniffing dogs be certified by an organization that provides reliable double-blind testing. Courts could also consider weighing the empirical reliability of drug-sniffing dogs in cases where that evidence is used to obtain probable cause to conduct a search. Police departments could also voluntarily hold themselves to that higher standard. But none of that will happen if folks don't talk about this and engage with their communities. Thanks for doing your part, Robert. Bob the Pilot writes, I've heard about this for decades. Why hasn't it made its way to the U.S. Supreme Court? Well, that's exactly what we at IJ are trying to do. The court has addressed several narrow aspects of forfeiture over the years, including in a case called Cully versus Marshall that the court decided earlier this year. But broader questions about the constitutionality of forfeiture remain unanswered, and it's clear now that at least 5 justices are interested in seriously examining the constitutionality of civil forfeiture in future cases. That's why we at IJ are working so hard to try and bring those cases to the public and the court's attention. Thanks again for watching. Make sure to like and subscribe and tune in to our next episode.